Good afternoon and welcome to today's webinar. My name is Sarah Bankson and I serve as Deputy Director of the Regulatory Transparency Project at the Federalist Society. We are honored to host today's discussion on the EEOC in the Trump era. Please note that the views expressed during this program are those of the speakers and not the Society. Following the discussion, we will open the floor to audience questions. You can submit your questions at any time using the Q&A function at the bottom of your Zoom window. It is now my pleasure to introduce our moderator, Eric Dryband, partner at Jones Day. Eric formerly served as Assistant Attorney General for the Civil Rights Division at the Department of Justice and as General Counsel of the Equal Employment Opportunity Commission. Thank you so much for being with us today, Eric. To learn more about today's speakers, I invite you to view their full biographies at regproject.org. Thank you once again for joining us, and Eric, the floor is yours.
Thank you, Sarah, and thank you everyone for taking the time to join us today. I'm delighted to introduce our two principal speakers. First, Professor Ryan Nelson. Professor Nelson joined the faculty at the South Texas College of Law in Houston in 2021. His research focuses on leveraging the civil litigation and other dispute resolution systems to advance the rights of poor and other marginalized workers, most often with respect to discrimination, harassment, wages, leaves of absence, and accommodations. Professor Nelson is widely published and has been published or will be publishing articles in such distinguished journals as the Michigan Law Review, the Fordham Law Review, the BYU Law Review, Yale Law and Policy Review, and online companions to the NYU Law Review, the California Law Review, and the Vanderbilt Law Review. Before he joined South Texas, Professor Nelson completed a research fellowship with the Harvard Law School Project on Disability and taught on the adjunct faculty at the Boston University School of Law, New England Law Boston, and New York Law School. He also spent nearly a decade practicing labor and employment law, including as an in-house employment law counsel for one of the world's largest financial services companies, and as an attorney with one of the top labor and employment law firms in the country. Professor Nelson obtained his LLM degree from the Harvard Law School, where he was awarded the Irving Oberman Memorial Prize for Best Paper on Law and Social Change. He obtained his law degree with honors cum laude from the Benjamin N. Cardozo School of Law, Yeshiva University, where he served on the editorial board of the Moot Court Honor Society, and his undergraduate degree in economics from the University of Florida, where he was a National Merit Scholar and became an avid fan of Florida Gators football. Bradford J. Kelly is a shareholder in the law firm of Littler in the Washington, D.C. office. He has a broad practice representing employers and employment anti-discrimination and wage and hour matters, and he is an internationally recognized workplace AI or artificial intelligence authority. Brad has published numerous articles about workplace AI and was also served as chief counsel to Equal Employment Opportunity Commissioner Keith Sonderling at the EEOC, where his portfolio included cases and policies, regulations about Title VII of the Civil Rights Act, and several other federal anti-discrimination laws enforced by the EEOC. He was also a key advisor to Commissioner Sonderling regarding the EEOC's initiative on artificial intelligence and algorithmic fairness, and Brad received the EEOC's Chair's Circle of Excellence Award for his extraordinary commitment to the agency. This is one of the highest honors conferred within the Commission. In addition, Brad serves on Law 360's Employment Discrimination Editorial Board, a role that he's had since 2022. And to round it out, he served also as a senior policy advisor with the Wage and Hour Division of the U.S. Department of Labor. So we have a very distinguished panel. Brad, I'll start with you. Brad, what is the EEOC? Who are its members and how are they appointed?
No, thanks a lot, Eric. I'm really excited to be here today and to engage in this discussion. I think it's a very important topic. But to start off, to kind of establish a baseline, what is the EEOC? So the EEOC is the federal agency responsible for enforcing workplace anti-discrimination laws in the United States. The EEOC was established by the Civil Rights Act of 1964, Title VII, and the mission of the EEOC is to prevent and remedy unlawful employment discrimination and advance equal opportunity for all in the workplace. Now, the EOC enforces a wide variety of federal laws that prohibit employment discrimination based on race, color, religion, sex, national origin, age for workers 40 and older, disability, and genetic information. The EOC is comprised of 5 commissioners and 1 general counsel, all appointed by the president and confirmed by the Senate. 1 commissioner is designated by the president to serve as chair or acting chair. Title VII also states that 3 commissioners constitute a quorum at the agency. And as of January 28th of 2025, the commission has 2 commissioners and thus no longer has a quorum. Commissioners at the EOC serve staggered 5-year terms, with no more than 3 belonging to the same political party. The chair of the EOC has a lot of administrative power and is responsible for overall policy direction. The vice chair and other commissioners participate in decision-making on enforcement and policy matters. Currently, the EOC has an acting chair, Andrea Lucas, and 1 Democratic commissioner, Kalpana Kotagal. The EOC's general counsel directs the EOC's litigation program and ensures coordination between legal and enforcement strategies. Currently, Andy Rogers is serving as the acting general counsel of the agency. Now, the EOC's main responsibilities include a wide variety of aspects, such as investigating complaints of discrimination filed by employees or job applicants, mediating and resolving disputes between employers and complainants when possible, litigating cases in federal court when violations are found and not resolved, issuing guidance and regulations to help employers comply with the law, conducting outreach and education to increase awareness of rights and responsibilities in the workplace, also monitoring workplace data and to identify and track different issues across that data. That's kind of a high-level overview of the EOC that hopefully will be able to kind of guide our discussion from here. And
Okay, Professor Nelson, what would you like to add or dispute anything we just heard from Brad?
Sure. Thank you so much for having me. I don't dispute anything Brad just said. It sounds all accurate to me. I'll tell you all, my view was that from when President Trump dismissed, I guess let me give some context. So President Trump dismissed 2 commissioners in late January, Commissioners Samuels and Burroughs. And from the time that he announced that dismissal until about 2 weeks ago, my view is that those dismissals were unlawful and that the EEOC was what we would call an independent agency as contrast from an executive agency. This harkens back to a long line of cases we've had for about 100 years now that distinguish between an executive agency under which the president has really an unfettered right to remove regardless of any statutory limits, as contrast from an independent agency where the president's right to remove a principal officer can be restricted statutorily by Congress. And my view until May 22nd, so like 2 weeks ago, was that the EEOC was an independent agency. And I had developed that view based on the EEOC's quasi-judicial and quasi-legislative functions. So the EEOC lacks really what I would call strong judicial or strong legislative roles, but it does have quasi roles in those areas. So for example, the EEOC does not adjudicate the vast majority of charges of discrimination the way we would typically think of adjudication. However, they do adjudicate charges made by federal employees. So there is some adjudicatory role. And similarly, on the legislative side, you typically think of an agency engaging in legislation if they're promulgating regulations that carry the force of law. The big statute that the EEOC administers is Title VII, at least in my view, and the EEOC cannot promulgate any regulations that carry the force of law under Title VII, but it can under a bunch of other statutes. So the Age Discrimination and Employment Act, the Americans with Disabilities Act, GINA, the Genetic Information Non-Discrimination Act, the Pregnant Workers Fairness Act. The EEOC has a lot of what I would call legislative authority in those areas. So my view leading up until 2 weeks ago was that those non-executive functions of the EEOC, in addition, combined with its power as an agency where there are these 5 commissioners, as Brad described, there's a nonpartisan balance between them. Usually it's 3 and 2. This is separate from the sort of executive agencies that the Supreme Court has pretty firmly confirmed the president has an unfettered right to remove. That changed 2 weeks ago. So 2 weeks ago, the Supreme Court stayed a lower court opinion in a case called Trump versus Wilcox. In Wilcox, there was a NLRB and MSPB, different agency members, who were challenging their removals by the president, alleging that they are protected from removal by operation of statute. The Supreme Court, in a shadow docket opinion, we have not yet had merits briefing, stayed a lower court case there, and the exact language that befuddled me but is law now is that there is a high likelihood, or a likelihood, that these agencies, the NLRB and the MSPB, are executive, and therefore that the president can remove their principal officers at will. The Supreme Court did not give us any reasoning for its conclusion, but assuming that is the law, and further assuming that they don't change that view upon further merits briefing, which will be forthcoming, I see no material light between those agencies and the EEOC. Certainly nothing that would justify saying that the EEOC is independent, the likes of which I thought it was until 2 weeks ago. So I think the import of that, building off of what Brad was saying, is that I think this Supreme Court will uphold the removals of EEOC Commissioners Samuels and Burroughs. Samuels has challenged her removal. To my knowledge, I don't believe Burroughs has filed anything that I've seen yet challenging her removal. I don't think those challenges will go anywhere, and I think the import of that is that if this ever climbs up to the U.S. Supreme Court, I think they will find that the EEOC is an executive agency, that the president can remove the commissioners and the general counsel at will. It is worth saying we technically don't have confirmation of that, but I don't see any way around it after this stay in the Wilcox case.
Thank you, Professor Nelson. Brad, any thoughts?
Yeah, I'll just add, kind of taking a step back here about this debate over whether these agencies are executive agencies versus independent. I think it's really important to keep in mind that, as I mentioned before in the overview, that the president appoints all 5 members of the EEOC, and the president, are appointed by the president and confirmed by the Senate. There's a lot of executive control. I was the political appointee in the first Trump administration, and I was a holdover in the Biden administration, and seeing the transition from one presidential administration to the next, especially with a change of parties, you see how much power the presidents have over these agencies, and they're appointed by the president, confirmed by the Senate. But the chair of the EEOC, who's able to be appointed, by the president, has a lot of administrative power and has a lot of ability to kind of set policy direction and enforcement priorities. And I think it's just really important to stress how much influence that executive control has and that executive power. And I think that it really does. I feel as if, that definitely it's evolved to a point where, these are executive agencies. I think, especially having served in administration and seeing, the changes there, I feel very strongly that, you can't, I don't see how these are not executive agencies at this point.
Professor Nelson.
Well, I agree for the past week and a half. I think it's inescapable now. But I was not convinced of that based on the operations of the agency prior to the Wilcox opinion. For example, the EEOC can choose whether or not to bring litigation without having to get approval from anybody else in the executive branch. The EEOC can choose to issue guidance or promulgate these regulations under non-Title VII statutes without getting approval from anyone in the executive branch. So my view had been this is pretty darn close to what independence looks like, and barring the Supreme Court giving further guidance delineating between executive versus independent agencies, it looked rather independent. But now we have a one-sentence throwaway in a shadow docket ruling telling us otherwise. I think I got to defer to that.
Well, Ryan, I'd like to ask, because one thing that I feel like looking at is that, as far as the debate between independent versus executive agencies, is that the will of the people. If you not happy with the current administration, you're like, oh, President Biden campaigned to be the most pro-union president, and he, largely was. And if you say you want to reject that, the voters rejected that, and you're saying that if an agency is independent, then it doesn't matter what those voters elected. So I think that that's an important kind of part to kind of weigh, is that I feel as if, that even if you're not happy with the direction of the EOC or the NLRB, you go to the ballot box and you say, well, we want a new administration. And I think that if you're saying that if it's an independent agency, you're saying that has no impact, that doesn't matter. And I feel like that's the reason that I feel like looking at these agencies, elections do have consequences, and you can reject the agenda of the current president and allow a new slate. And I think especially now, with a lot of the agencies partnering with other executive agencies, including the Department of Justice, I don't see you could break it away and say these are independent agencies.
I mean, I'm with you now. but I think the reason I'm with you is because the will of the people, sure, it's absolutely seen through election of the president, but it's also seen through election of Congress, right? I mean, we've got Article 1 for a reason. It's first. And if Article 1 puts restraints on independent agencies, I mean, my view would be to defer to that, and I guess to have a less robust view of the independent executive theory, or one flavor, I should say, of that theory.
Professor Nelson, you mentioned the Wilcox case, and I do want to ask about your views of the fact that the National Labor Relations Act, which is a relevant statute in former member or former current, however you want to look at it, member Wilcox's case, that statute does at least provide limitations on the president's authority to remove board members. The statute that creates commissioner positions at the EEOC, Title VII, as you know, does not have any protections like that against removal. Does that matter from your point of view with respect to the president's authority to remove commissioners?
Yeah, it's interesting. So I think the best answer is probably not, but it's worthy of a little bit of discussion. I'd be interested if Brad agrees or disagrees with this. So the general standard that Congress usually adopts whenever it puts in place restrictions on an independent agency's removal is the INM standard, right? So inefficiency, neglect of duty, or malfeasance, INM. And yes, there are differences, but that's pretty basic. I haven't looked at the NLRA for a bit, but I would be reasonably confident that it matches the INM standard or something materially identical. That said, to Eric's point, Title VII doesn't have anything like that. So it begs the question, okay, are these just, once they're appointed, no one can ever remove them forever and always? This seems rather ridiculous. What I probably draw the closest parallel would be, I don't know, let's say a private employment contract that guarantees you a term of employment for a year, but doesn't specify how you can terminate the individual. In most states, I mean, certainly my state of Texas, if there's a contract like that, what's read in is a just cause standard. So I would presumably read in some form of just cause standard when there is silence. In the case of Title VII, that's a good example. I know, Brad, what are your thoughts?
Yeah, I generally agree. I mean, I feel like I mean, as far as the Texas point, I mean, I thought it was mainly kind of employment at will for, most of that. But I mean, I guess reading into it. But I do think that, again, if you even want to look to cause, I mean, again, going back to the elections have consequences, I do think that you could say that, the will of the people is cause for, the executive power there. So I do think you can look to the idea that elections do have consequences.
Yeah, I just don't agree with that part. I just think, I mean, to give further examples, so it's not just President Trump that has been removing office. President Biden allegedly did the same thing, right? I mean, he purported to remove the general counsel of the EEOC. I thought that was unlawful. I think that the President Trump's doing the same thing. Well, I should say before 2 weeks ago, I believed that to be unlawful. Now I believe that is lawful, and the Supreme Court would say the same.
Well, and Ryan, I think that's a very good point that, for historically, I mean, President Biden not only fired the EOC General Counsel, Sharon Gustafson, but he also fired the General Counsel of the NLRB when he came in. And even as far as the Abruzzo being fired at the NLRB at the beginning of the Trump administration, they're going to use the same arguments that were raised by, NLRB General Counsel Abruzzo when she was terminated. So I feel like and I think it's an interesting question where, you're seeing this back and forth now with, there's usually in labor and employment law, there's this ping pong effect that with Republican administrations, it's very pro-employer. And then during Democratic administrations, it's more pro-employee/union. And, so I feel like where is that ping pong effect going to go next? I feel like that's a very interesting question as well. And I don't know the answer to that.
And I'd like to just shift a little bit, but
real quick, Eric.
I'm going to turn it back to you, but I do want to say whatever you want, but I do want to raise an issue about guidance and websites. That is, EEOC is issuing guidance without a quorum. District Court in Texas enjoined the commission's harassment guidance. Could you just speak to that? But again, if you want to speak to this executive agency issue too, and then maybe segue to that next issue.
Totally. I don't have anything new to say about the agencies. The only thing I would note for the audience is that the president has nominated enough commissioners now that if they're confirmed by the Senate, we will have a quorum. So the president has renominated Acting Chair Lucas, and the president has nominated, I don't know if I'm pronouncing the last name, Brittany Panuccio, to serve as one of the other commissioners. So assuming Senate confirmation, we would then have 3 out of the 5. And we would have indisputably a quorum. I should add for any and then I'll move on to your question, Eric. For any admin law nerds, prior to 2 weeks ago, not only did I think it would have been unlawful for the president to have removed the commissioners, but I further thought that one of the remedies would be a declaratory judgment that they had never been lawfully removed at all. And that my view until 2 weeks ago was that the EEOC actually never lost quorum. And that there have been 4 sitting members the entire time. I drew parallels to some colleagues of mine saying if the president had, tweeted or truthed that I hereby remove a member of Congress, we wouldn't bat an eye. We would say, no, they're still in their office. And similarly here, if this is unlawful, similarly, they're still in their office. But that said, I think all of that is moot and much more theoretical at this point, because my view is currently that the EEOC is an executive agency. So to turn to Eric's question about guidance. So the EEOC is rather peculiar for a number of reasons, but one of the reasons is the sub-regulatory website guidance that it promulgates. I mentioned this earlier, and I don't think there's dispute on this point, that under Title VII, EEOC does not have congressional authority to promulgate regulations that carry the force of law. Based on that premise, it has always been utterly bizarre to me that the EEOC publishes what it would call technical guidance. And to be fair, the statute does direct the EEOC to promulgate technical guidance, but I think they have gone quite a bit further than that. And this is not a feature of, in my view, not a feature of a Democratic or Republican administration. This is just something the EEOC has done for a long time, which is we created these websites that read as if the EEOC is legislating when Congress has not given it that authority. So Eric mentioned one example was that under the Biden administration, the EEOC promulgated guidance about workplace harassment. This is the first time in quite some time that they did so. One of the aspects of the new workplace harassment guidance was to incorporate the Supreme Court's opinion in Bostock versus Clayton County, which held that sexual orientation and gender identity discrimination constitutes sex discrimination under Title VII. Just a couple of weeks ago, a district court here in Texas vacated those portions of the EEOC's guidance. And I think it's fair to say those portions are not law. What's bizarre to me is that I kind of see these guidance and shrug, and I'm like, who cares? It's not law anyway. So whenever I was advised in private sector and I would advise my employer clients on any of these guidance, if they come to me and say the website says X, Y, and Z, what should we do about it? I would say, well, I think it's predictive, but not restrictive. I think it is predictive in the sense that it predicts what position the EEOC will take if you have a charge or if you've got a litigation, even though those are few and far between. But I do not view the EEOC's guidance. It certainly did not carry the force of law even pre-Loper Bright, and now post Loper Bright. I certainly don't think this website guidance is that significant. It is interesting that the EEOC has published some, I wouldn't call it that hearty of guidance, but they've published like an FAQ, for example, in the past couple months, which is weird because the EEOC doesn't have quorum to do anything. So I don't really understand who is directing them to publish websites. But nonetheless, my view is to take any of those website guidance with a very large grain of salt because I don't view them as that significant.
Professor Nelson, if I can just follow up, and then Brad will come to you.
Mm.
Are you referring with your remarks only to Title VII guidance, or are you referring to
Yes.
guidance of any statute? If you could just elaborate briefly on that.
Yes, thank you for the clarification opportunity. Yes, only with respect to Title VII. So with respect to statutes like the ADEA, Title I of the ADA, GINA, the PWFA, the EEOC does have congressional authority to promulgate regulations that carry the force of law. Those are something that you should pay quite a good deal of attention to because they are law. In contrast, if you see website guidance that purports to delineate issues regarding race, color, national origin, sex, or religion, the 5 bases of anti-discrimination outlined in Title VII, the EEOC does not have the authority to promulgate regulations that carry the force of law with respect to Title VII only.
Thank you. Brad, thoughts?
Yeah, I think I'll just add here that, from as a private practitioner, someone who spends a lot of time advising, clients, is that sometimes the guidance is useful in providing something just as far as where the EEOC stands. I mean, the EEOC just recently put out guidance on DEI that I thought was incredibly helpful. So I do think that, and I do agree that it's at least to show what the EEOC's position would be and how the EEOC would respond. And I think that a lot of the guidance when I was at the EEOC, we put out religious discrimination updates, and there had been a lot of significant decisions on religious issues, including the ministerial exception after the Our Lady of Guadalupe case. And we took, there was a lot of, even for the religious guidance we put out, it was subject to notice and comment. We got a lot of very useful comments from, a whole host of nonprofits, employers, employee groups, and so forth. And it was able to provide, we were able to provide enhanced guidance. We were able to take the comments and say, well, this is the feedback we're getting. And I do think it is useful. I do think that there's a lot of guidance documents that at least help provide employers with the idea of what the EEOC is looking for, what right looks like and what wrong looks like. So I do think there's a lot of value in having that guidance. And, especially when there's, different hearings held and notice and comment, I think that could really be helpful. And I do a lot of artificial intelligence. And, in the age of AI, there's so many questions from employers about the use of AI tools in the hiring process. And guidance can be helpful. And I do think that it's important for these agencies to, try to help employers and employees, unions, et cetera, provide some sort of answers to these questions that are out there.
And Brad, is there some issue, you mentioned AI and guidance, is some issue about revocation of the EEOC's artificial intelligence guidance?
Well, most of all of the EEOC's AI guidance has been pulled from the website at this point. And I do think that, it's, so there is some guidance out there on artificial intelligence in the workplace, but a lot of the best guidance out there is, making sure that you comply with existing law. Don't, make sure that if AI tools are being used to screen out applicants on the basis of disability or race, for example, that would be in violation of Title VII and the ADA. So I think it's important to really focus on how these new tools fall within and the application of existing law to those new tools. So I do think I'm hopeful that the EEOC will put out new guidance, and Department of Labor will put out new guidance as well. Just today, the U.S. Department of Labor announced that they're going to be restarting the opinion letter process. So they're going to be taking in questions from the public and issuing opinion letters. And I'm hopeful that they'll issue opinion letters on artificial intelligence, how to comply with the Fair Labor Standards Act, for example, if you're using AI tools for compensation decisions. I think that would be particularly helpful. So I think that there's ways for the government to look for just providing additional guidance in a whole host of areas.
Professor
Yeah,
Nelson, thoughts?
I largely, I think I agree. The only quibble that I have is I completely agree with Brad that the guidance is helpful. But like, if I wrote a really in-depth law review article opining on what I believe Title VII says, that would be helpful. And if I had a megaphone, it might be as helpful as the EEOC's. But Congress gave me and the EEOC equal authority to interpret Title VII, which is none. So like, yes, it's helpful, but like I just don't. I think there is a fine line the EEOC has to walk between issuing the statutorily mandated technical guidance versus what I would view as sort of legislating and adding in helpful but congressionally not approved sub-regulatory websites.
Professor Nelson, could you just you say that you have the same authority. I mean, Title VII does contain a provision that authorizes the regulated parties to rely on written interpretations and instructions of the EEOC under Section 713 of Title VII, and to avoid liability if they do so. Is that any kind of a grant of regulatory authority that matters?
So I don't think so. Well, for two reasons. So one is that Section 713 only permits instructions that you rely on instructions of the commission. And if the commission lacks quorum, I don't think you can qualify that as being an instruction of the commission. Similarly, the formal guidance documents that the EEOC promulgates, for example, the harassment, are subject to a commission vote, right? So you can say that this is an instruction of the commission, but not everything goes through that level of rigor. So there is a chance that some of the even lesser websites, the sub-regulatory guidance, still not something that you can rely on. And I think even if you surmount those hurdles, you're still going to run into the Supreme Court, where it is just pretty flatly said that Congress has not authorized the EEOC to promulgate regulations that carry the force of law under Title VII.
Okay, thank you. I want to shift a little bit now to charges and investigations. And Brad, could you speak to how does the statutes the EEOC enforces with respect to charges, whether they're public or not, whether the commission can publicize them, who can file them, subpoena power, things like that?
Yeah, so kind of most basic kind of function of the EEOC is when somebody files a charge with the agency. So they're alleging discrimination, and you have to fill out a charge statement, which includes, what's the basis for this? Is it, does this fall under Title VII? Is it under the Americans with Disabilities Act, Age Discrimination and Employment Act? And then the EEOC from that point will, provide the employer with the opportunity to provide a position statement, and there's all sorts of confidentiality protections during the investigation process. But there's also the ability for commissioners, so the 5 commissioners on the EEOC, to issue what's known as commissioner charges. And that's where it essentially means that a EEOC commissioner could say that there is a basis to believe that there may be a violation of one of the equal employment opportunity laws, and it kind of serves as the same purpose as a individual filing a charge with the EEOC. And that's kind of a high level overview of the kind of process that it takes place. And then the commissioner charge will go through the standard practice of the way that a charge is filed by an individual. Oftentimes requests for information, and if the request for information could lead to a subpoena, oftentimes there will be a deficiency letter before a subpoena is issued, and that's just kind of a high level view of the process involved.
Professor Nelson, and thoughts?
Yeah, I agree with all of that. I think what makes the most sense to think of this is that the sort of investigatory authority that the agency has, which includes subpoena power, is always downwind of a charge. So there has to be a charge first for the EEOC to have statutorily authorized investigative authority. And that charge, just like Brad said, almost always it's a charge by a person claiming to be aggrieved, which is usually a former, current, or a potential employee. However, it can be a commissioner's charge. And something to kind of underscore here, it is a commissioner's charge. It's not the commission's charge. So any commissioner can file a charge under penalty of perjury that the statute has been violated, then an investigation can commence. I raise this because I'm sure a lot of folks in this audience have probably seen that Acting Chair Lucas sent letters to about 20 large law firms in the country that alleged that there was suspicion that the law firm had violated Title VII, and she had requested that the firm provide a bunch of information to an EEOC web email address. So I think this is a good way to examine the agency's power. So at the time she sent this, the agency lacked quorum. And that said, there was nothing that could stopped her from being a commissioner from filing a commissioner's charge against these law firms. However, none have been publicized. As Brad mentioned, it's unlawful. It's a crime for any officer or employee of the EEOC to publicize a charge. However, that does not apply outside of the EEOC. So for example, if you're the recipient of a charge of discrimination, you're welcome to publicize it. But we have no knowledge that these law firms were recipients of charges of discrimination. My view, however, is that I found the letters to be imprudent. I did not find them to be appropriate, but I did not find them to be unlawful either. In my view, Acting Chair Lucas has her First Amendment right to speak. I see nothing wrong with writing a letter, or for that matter, going on the news, going on a social media app and saying, I have the following suspicions based on public information. I hereby request that employers send me information so I can further vet this. Her letter did not purport to come, these letters did not purport to come from the entire agency. They specifically said it was from the office of the acting chair. She did not purport to cite any statutory authority for what she was doing. I see no problem with it. I should add, by the way, however, that my view is that therefore this was not an investigation of the EEOC, and it is investigations that are protected from public disclosure. So I have a pending FOIA request for all emails sent to or received by that EEOC email address. I am interested to see what the result is, because if the opposition is that we don't publicize investigations pursuant to charges, that would surprise me, because I'm not aware of charges being filed prior to sending those letters.
I just want to follow up, Professor Nelson. First, thank you for that. First of all, just two questions related to these letters. One, you mentioned that Acting Chair Lucas was exercising her First Amendment rights. If you could explain, I'm not sure how federal government has First Amendment rights, and I'd be curious to hear your thoughts about that.
Yeah, no, you're probably right.
Okay, okay. Well, secondly, then,
I'll withdraw that point.
Secondly, the Title VII and I think EEOC's procedural regulations, which the Commission issued pursuant to the grant of statutory authority that you mentioned under Title VII, detail the enumerated procedures that the Commission says in its regulations that it will follow to enforce Title VII. And as you noted, that those letters did not cite any statute. They didn't cite anything from the regulations either that would authorize them. And so is it your position that they're lawful because they were just kind of informal letters that had nothing to do with Title VII enforcement, or that they are a mechanism by which the acting chair can enforce or seek to enforce Title VII?
I think my view is closest to the former of those two options. So to clarify, my view is that this was not an investigation under Title VII. I mean, it sounds to me, and keep me honest if you disagree, but it sounds like your view sounds like an expressio unius type of argument, right? That like the statute provides X, Y, and Z, and what Lucas has done is some other letter, and therefore not permitted by the statute. I don't read the statute as that way. I see nothing.
What about the regulations, though? I mean, the regulations say that the Commission will enforce Title VII by following the enumerated procedures in the EEOC's regulations. And that's it. I mean, so the Commission essentially has bound itself to certain procedural requirements that are enumerated in the regulations and is announced to the public through notice and comment rulemaking that these are the exclusive procedures by which the commission will enforce Title VII. So then that leaves the question of, oh, these letters may not be enforcing Title VII, but doing something else. Or what's your view on that?
Yeah, certainly something else. I mean, it's not a Title VII investigation. I mean, the commission isn't acting. We haven't had a commission for a couple of months. It's like, it's certainly not a pursuant to the commission's regulations that you mentioned. I view this as closest to a commissioner going on TV and saying, I heard something about an employer acting unlawfully. Here's how you can get me information. Again, imprudent. I didn't think it was appropriate. And I would go further. I think that, for example, some of the evidence cited in the letters I found quite repugnant and not reflective of potential Title VII violations. They cited law firms' websites as having too many students of color posted on them. I was shocked by some of the things in these letters. I found them absolutely disgraceful. But I see nothing in either the statutes or, to your point, the regulations that would cross the barrier into unlawful.
Brad, thoughts?
Yeah, I think I think that I don't have much to add. I think that, it's a request. It's, from that. And I think that, I have nothing to add to those points. I think that, there's two very good arguments involved there as far as, for both for and against. I have nothing more to add.
Actually, can I wait one quick note, because that made me think of something where I suspect we'd be aligned, but keep me honest, of course, Brad and Eric. If I represented an employer that received a letter similar to this, I think my advice to them would be, look, I see nothing in the statute that compels you to respond, but I also think you should play nice with your regulator. And I think that I would not be silent. I would not ghost the agency. I would respond with respect if that includes providing any documents that are requested as a way of trying to stave off a potential commissioner's charge and a follow-up investigation with subpoena power. I certainly think that is a reasonable risk mitigation technique that an employer might undergo.
Yeah, and I have no issue with that. I think, that sounds aligned with, advice that I would give.
Let me ask Professor Nelson and Brad, I want to get your take on, there was a recent report that Acting Chair Lucas filed a commissioner's charge about certain practices at Harvard University. And so I really would appreciate, number one, your thoughts about the fact that that charge is public. It's not, I don't know who made it public, but it is public. How did that happen if there are these penalties, including criminal penalties for publication? And secondly, your thoughts generally about the charge. So we'll start maybe Professor Nelson with you, then Brad, get your thoughts on that.
Sure. I thought it was a fairly standard commissioner's charge. I guess starting with the publicity aspect, I have no reason to suspect that anyone at the EEOC publicized this. I have no knowledge. And if it was anyone on the receiving end of Harvard who chose to publicize it, there's nothing unlawful about doing so. In terms of the content, I thought it was fairly usual. The only thing that kind of struck me as a little odd is, and this is something the agency does all the time, so I wouldn't say it's that odd, is citing current demographics, like a static picture of the workforce of Harvard as evidence of their payroll or their practices. So like, we suspect that the fact that you have X% people of a certain race is predictive or indicative of your hiring practices or any of your other personnel practices. I have always tried to convince the agency that those are just very different worlds, that one is a static view, one is dynamic, one does not necessarily talk to the other. So I didn't view that evidence in the Harvard commissioner's charge as compelling at all. But I guess from here, we kind of wait to see what happens. The EEOC can choose to litigate this. I guess to build on our earlier discussion of the EEOC's powers with and without quorum. So the EEOC has delegated its litigation authority in large part to its general counsel, but not entirely. So if the EEOC decides that this Harvard case or really any other case, any other charge is indicative of a pattern or practice discrimination, systemic discrimination, anything that's just going to cost the agency a whole bunch of money, it's really for the EEOC to decide whether or not to initiate litigation, and unless and until it has quorum, it lacks that authority. However, if this is something that's more of a run-of-the-mill case, not systemic discrimination, then the GC has the authority to bring litigation. So we may see litigation here, kind of depending on the acting GC's view of this case.
Okay. Brad, any thoughts?
I think one other thing I'll add to that is just the executive order that the Trump administration on disparate impact. There's two theories of discrimination in employment discrimination law. It's disparate treatment, which means it's intentional discrimination, and disparate impact, which it means unintentional. And the Trump administration's executive order directed the EEOC to, basically the EEOC, FTC, and a number of other agencies, that there will not be a pursuit of cases involving disparate impact theory. And I think it's going to be interesting to see how that impacts investigations, including in the DEI space. And I think that's something that, just to kind of keep our eye on where that's going to go. And speaking about artificial intelligence earlier, I think that it's going to definitely impact the EOC's view of artificial intelligence. In most cases, the use of AI tools, if they're possibly screening out people on the basis of race or gender, etc., most of that time it's going to be a disparate impact theory. So I do think that executive order is going to have a big impact on a number of different areas within the EOC.
Thank you. I want to shift a little bit now to some of the commission's priorities. Professor Nelson, could you speak to particularly issues about gender ideology, anti-Semitism, anti-American bias, protecting women, things like that?
Sure. So those four that you've just identified have been the publicized new priorities of the EEOC. I guess the two that I'll just briefly note that struck me, the gender ideology piece and the anti-American bias piece. So on the gender ideology piece, the EEOC took a rather unusual position of moving to withdraw from 7 pending EEOC-led civil actions where the cause of action was gender identity discrimination filed by a charge by either a non-binary and or transgender employee. So the EEOC withdrew from these actions effectively, or moved to withdraw. It strikes me as potentially problematic, something I want to kind of keep my ear to the ground from an equal protection clause view. What strikes me is that this administration has exhibited rather public anti-trans bias. To give an example, in the president's executive order banning trans members of the military, he explicitly called trans people not honorable, not truthful, and not disciplined. I don't know that you get much more explicit bias than that. It reminds me of the Arlington Heights type case. And when I see an executive agency under the direction of this executive decide to withdraw support from trans workers, it suggests to me that there could be potential problems there. I'm hedging quite a bit because I want to see how this plays out. I mean, certainly I want to see what are the bases for standing, for example. What I would imagine is if a worker comes out of the woodwork and says, look, I was really relying on the agency litigating for me, I don't have the resources to, I would be interested in seeing a potential Arlington Heights style challenge to the EOC's actions. And then the second piece of the priorities that I'll comment on, the one with which I actually strongly agree, is the anti-American bias. The EEOC has not fleshed this out really. We don't have a lot of meat on the bones of what this means. What I sincerely hope that they believe this includes is the bias that I see when I represented employers when it came to work authorizations in the United States, specifically H-1 visas, where as part of the statute, there is a requirement that you cannot give like an H-1B visa unless if there is a qualified American citizen. For any of you in the audience who have advised employers, you know that that is largely a paperwork exercise, and a lot of employers try to skirt the rules, and in my view, exhibit anti-American bias. I would absolutely love for the EEOC to take on that as part of their charge to combat anti-American bias. I don't know if they will. Hopefully, once the commission is constituted and we have a quorum, we'll get a little bit more information about these 4 new priorities.
Brad, I'm going to just transition. Thank you, Professor Nelson. Brad, a couple things just throw out for you, and then I do want to preserve some time for questions. So, anti-American bias, EEOC versus the National Labor Relations Act, USERRA, politics in the workplace, and the new administration. Brad, what are your thoughts?
I think just
in
kind
a few minutes, because like I said, I'm going to cut it off here because we have some very important questions I want to get to.
Yeah, I think one thing I want to stress is that, as far as the president's priorities and the priorities announced by Acting Chair Lucas, is that they have the ability to, kind of prioritize. I mean, the EOC, like every government agency, has limited resources in many ways, so they're able to prioritize what they will focus on. And I think that during the Biden administration, when I was at the EOC, there was a lot of criticisms from religious groups saying, that they're not putting a proper focus on the COVID vaccine exemptions, especially for religion. That just wasn't a priority, during the Biden administration. There was a lot of criticism of that. So I do think it's important to stress that, the president can establish, the priorities and what the enforcement focus will be. And I think with an anti-American bias, I think that is largely, it's going to be tied with a lot of the immigration issues. I think this will be a very interesting area to see how it develops, and hopefully there'll be some additional guidance out on this. But those are the main points I wanted to add there.
Okay. I'm just going to start on questions, just so we get some of the questions out. I'm going to start with one, Brad, for you. The question reads, I'm just going to read it. It's surprised Brad does not find the, quote, too many Black people in the photo, close quote, paraphrasing, repugnant. Why would he choose not to take the opportunity to respond similarly? So, Brad, any thoughts about that? I think this is a reference to Professor
the
Nelson.
Harvard.
Go ahead, yeah.
Yeah, I'm not familiar.
About the letters to law firms, I think, is that?
Yeah, I'm not familiar with that exact, for that charge, what that's in reference to. So I don't have familiarity on that.
Okay. Thanks. I want to, next question. This is about the will of the people. So, and maybe Professor Nelson will start with you and then to Brad. Is the will of the people a rationale that covers most, if any, presidential action? How far do we take the unitary executive theory? It would seem to undermine the principles of a democratic republic built on checks and balances. Professor Nelson, thoughts about that?
Oof. I mean, yeah. How much time do we have? But
well, we're at diminished time, but I'm trying to, at least get.
I mean, look. Whenever you're talking will of the people, you're talking direct will vis-a-vis Articles 1 and 2, indirect vis-a-vis Article 3. I view separation of powers, both horizontal and vertical, as the most important feature of our Constitution. I think anytime you tweak with the separation, it must be done with incredible nuance and care, because I am terrified of upsetting that balance. And one thing that absolutely terrifies me is that it seems like in the past 5 to 10 years, the current Trump administration and the current Supreme Court have tweaked the balance quite significantly. So without going into great specifics on various flavors of the unitary executive theory, my view is that the Supreme Court is not going to they're certainly not going to go so far as just to say the executive gets to control, the president gets to control absolutely everything. There's going to be a carve out for the Fed. They're still going to at least nominally maintain a Humphreys executor and the inferior officers exception. But I think, look, broadly speaking, you have a point that you want to try to respect the will of the people, but I certainly don't think that is exclusively represented vis-a-vis the president.
Brad, thoughts real quick? No?
No, I think I largely agree with that point.
All right. We have another question that says, and maybe I'll start with you, Brad, and then we'll go to Professor Nelson. President Biden fired General Counsel Gustafson. Is there a difference? And let me, for the audience, those who may not know, she was the General Counsel of the EEOC during President Trump's first term. So President Biden fired General Counsel Sharon Gustafson. Is there a difference between commissioners and the General Counsel when it comes to the theory of an independent agency? Or is that something that was unlawful until 2 weeks ago? So maybe Brad will start with you, and then Professor Nelson will go to you. So Brad?
No, it's a good question. I forgot under the under Title VII, I think that it's pretty much the same as far as, for what the I don't think there's exact protections, that exist there for, that would be different for the general counsel versus the commissioner. So I think, and I don't believe Sharon Gustafson, when she was fired by Biden, I don't believe there was a legal challenge. So I don't think that has, that issue has been litigated. And I don't believe that there's been a legal challenge from when Carla Gilbride was fired either. So it's going to be interesting. It's a very interesting question.
Professor Nelson?
I agree. I don't think there is material light between the GC versus the commissioners when it comes to independent versus executive. To Brad's point, this Title VII does not differentiate between like giving limitations on the removal of one versus the other. They're both presidential appointees with Senate confirmation. The only potential light I could see would be invoking the CFPB case, where the Supreme Court did seem to think that the fact that the CFPB was led by an individual made it more executive. That seemed to matter. And the GC doesn't lead anything similar to that, but does have independent authority to make decisions, contrast from the commission that is 5 members. So I suspect the strongest argument I could make is that if there is any light between the GC and the commission, perhaps the GC is even more executive than the commission itself. So I think even 2 weeks ago, I probably would have taken the position that the GC and the commissioners were all members of an independent agency and cannot be removed. Today, I don't think that argument has traction.
Professor Nelson, let me just follow up on that. And what about the functions of it? Because the general counsel of the EEOC's responsibility is defined by the statute is to be responsible for the conduct of litigation. The general counsel does not have regulatory authority to adjudicate anything or to issue rules or regulations or sub-regulatory guidance or anything like that. Does that matter in terms of whether the general counsel is more executive than, say, the commissioners?
I haven't thought about that enough. So working on the fly, I would probably say it doesn't compel me, but it also just seems so academic at this point that I think it probably doesn't matter anyway.
Yeah, and academic because of the decision 2 weeks ago, is that?
Correct. Yeah. And look, to be fair and to clarify for the audience, that was not a full briefing on the merits. We don't have a definitive case. There's been a lot of bluster on social media that Humphrey's executor has been overturned. I think that's wrong. It has been chipped away and I think will be further chipped away, but it is not gone by any means. I just think that based on that Wilcox opinion, yes, I think that currently the agency is certainly looks and feels like it's an executive agency.
Okay. We're going to have to wrap it up then. Brad, any final thoughts? And then I'm going to turn it back to Sarah.
No, this has been very enjoyable. I've really enjoyed this conversation. Thank you very much for having us today.
Agreed. Thank you all so much.
Okay. Sarah?
Great. Well, on behalf of the Federalist Society, I want to thank all of our speakers for sharing your time and expertise with us today. And to our audience, thank you for tuning in. If you'd like to see more content like this, please visit our website at regproject.org. Thank you all again, and I hope you enjoy the rest of your Monday.